The Supreme Court opinions in Roe v. Wade and Planned Parenthood v. Casey have been political footballs since the day they were decided. A recent Mississippi law placed restrictions on abortions within that state that contradict the standards set by Roe and Casey. Not surprisingly, a lawsuit was filed challenging the Mississippi law. Recently, oral arguments in this case were heard at the Supreme Court. I found a number of arguments that I believe anyone interested in what the Constitution actually says would find worth their time. So we'll discuss that next on the Constitution Study.
You have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans, and welcome to the Constitution Study. This is where we read and study the Constitution. We teach the rising generation to be free. Glad you could join me. Now, as always, you can find out more at constitutionstudy.com. Please do. Please, I'm looking for questions to answer. I have a live Q&A twice a month on the second and fourth Thursday of the month, and I'm looking for questions. If you can't attend live, well, feel free to ask a question online and then follow up later with the video. Now, I'll talk more about that site and some other things at the end of the video, but let's start with this question of Dobbs versus Jackson's Women's Health. The plaintiff, Thomas E. Dobbs, is the state health officer for the Mississippi Department of Health. In 2018, Mississippi enacted the Gestational Age Act, which prohibited abortions after 15 weeks gestation, except in medical emergencies or where severe fetal abnormalities were found. Jackson's Women's Health sued in federal district court and won. The case was appealed to the Fifth Court, which agreed with the district court. Mr. Dobbs then petitioned the Supreme Court for review of the case. Scott Stewart, the Solicitor General of Mississippi, argued first, and he started out with a bang. Mr. Chief Justice, and may it please the court, Roe versus Wade and Planned Parenthood versus Casey haunt our country. They have no basis in the Constitution. They have no home in our history or traditions. They've damaged the democratic process. They've poisoned the law. They've choked off compromise. For 50 years, they've kept this court at the center of a political battle that it can never resolve. And 50 years on, they stand alone. Nowhere else does this court recognize a right to end a human life. I've talked before about the Roe opinion, but I believe Mr. Stewart is just as correct about Casey. Both claim that a woman's right to liberty supersedes the right to life of the child in the womb, at least until the point of viability. Now, as I understand it, the main difference between Roe and Casey is Roe used an arbitrary trimester approach, while Casey used an arbitrary undue burden one. See, Roe divided a woman's pregnancy into 3 trimesters and set conditions and exceptions on that schedule, while Casey looked to see if the state law imposed an undue burden on the exercise of a woman's liberty to terminate her pregnancy. Now, both found this right to abortion in the 14th Amendment's Due Process Clause, specifically the right to not be deprived of liberty without due process of law. For 50 years, Roe and Casey have been at the center of a political battle, and the court has been a willing participant. When was the last time the confirmation of a federal judge did not include the question of whether or not they support Roe? How long has the Senate used the stare decisis as a sword of Damocles above the heads of nominated judges, requiring a demonstration of fealty to the right of abortion? Mr. Stewart pointed out, consider this case. The Mississippi law here prohibits abortion after 15 weeks. The law includes robust exceptions for a woman's life and health. It leaves months to obtain an abortion, yet the courts below struck the law down. It didn't matter that the law applies when an unborn child is undeniably human, when risk to women surge, and when the common abortion procedure is brutal. The lower courts held that because the law prohibits abortions before viability, it is unconstitutional no matter what. To me, the law in question seems more than reasonable, even if 15 weeks is just another arbitrary time frame. However, Justice Breyer points out the crux of the question. What stare decisis principles should be used to overrule a case like Roe? And they say Roe is special. What's special about it? They say it's rare. They call it a watershed. Why? Because the country is divided, because feelings run high. And yet, the country, for better or worse, decided to resolve their differences by this court, laying down a constitutional principle, in this case, women's choice. All right, That's what makes it rare. While oral arguments discuss many questions about the Mississippi law, the big question revolves around stare decisis, Latin for let the decision stand. Justice Breyer says they claim Roe is special because it is rare, but how rare is it? Sure, there aren't many cases about abortion that get to the Supreme Court, but there are plenty of cases where the court has found a right that isn't in the language of the Constitution. Breyer says people claim Roe is special because the country is divided, but the country is divided over many things, not just abortion. Then Justice Breyer claims the country decided to resolve these differences by having the court lay down a constitutional principle. However, the country did not ask the court to decide this issue. A small group of activists did. The country did not consent to the court's laying down constitutional principles, but the court did. Now, Justice Breyer went on. That's not what I'm asking about. I want your reaction to what they said follows from that. What the court said follows from that is that it should be more unwilling to overrule a prior case. Far more unwilling we should be, whether that case is right or wrong, than the ordinary case. That, to me, is the crux of the matter. Because that is what really makes Roe and Casey rare and dangerous. The court's unwillingness to change its mind even when it's wrong. Of course, according to Justice Breyer, it's not the court's fault. And why? Well, they have a lot of words there, but I'll give you about 10 or 20. There will be inevitable efforts to overturn it. Of course there will. Feelings run high, and it is particularly important to show what we do in overruling a case is grounded in principle and not social pressure, not political pressure. Only the most convincing justification can show that a latter decision, overruling, if that's what we do, was anything but a surrender to political pressures or new members. And that is an unjustified repudiation of principles on which the court stakes its authority. The reason the Roe and Casey decisions are wrong is not because feelings run high. And the reason to overturn it has nothing to do with political pressure. In fact, I would say it is political pressure that has kept these bad opinions around for so long. So why does Justice Breyer believe the court should be so reluctant to overturn precedent? Overruling unnecessarily and under pressure would lead to condemnation, the court's loss of confidence in the judiciary, the ability of the court to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. Isn't it the fact that courts are so reticent to change their minds on a wrong opinion that truly causes a lack of confidence in the judiciary? How can a member of the court claim it is the court of a nation dedicated to the rule of law if they place previous opinions above the law? So apparently, it's not enough for the court's decision to be wrong. It must be really, really wrong. It seems the court is more concerned with their reputation than upholding their oath of office. Now, Justice Breyer wasn't the only one to bring up politicization. Justice Sotomayor took a slightly different angle. What hasn't been at issue in the last 30 years is the line that Casey drew of viability. There's been some difference of opinion with respect to undue burden, but the right of a woman to choose, the right to control her own body, has been clearly set for, since Casey, and never changed. You want us to reject that line of viability and adopt something different. 15 justices over 50 years, or I should say 30 since Casey has reaffirmed the basic viability line, 4 have said no, 2 of them members of this court. But 15 justices have said yes, of varying political backgrounds. Now, the sponsors of this bill, the House bill in Mississippi, said we're doing it because we have new justices. The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsors said we're doing it because we have new justices on the Supreme Court. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts? The question of when a child in the womb receives legal protection has been the central issue since Roe was decided in 1973, almost 50 years ago. While the Roe case, later reaffirmed by Casey, set that milestone at the point of viability, that only settled the controversy in the minds of the justices. Every year since the Roe decision, thousands of people per year have demonstrated on the steps of the Supreme Court their unwillingness to accept the court's decision. Justice Sotomayor asks if the court will survive the stench of the perception that their interpretation of the Constitution is merely a political act. Since everyone currently on the court had to pledge fealty to Roe v. Wade as part of their confirmation in the Senate, I would say they have been living under that stench for almost 50 years. The question I have is, will this country survive the stench of denying constitutionally protected rights to the most vulnerable among us simply to appease a political party? Justice Sotomayor went on. Virtually every state defines a brain death as death, yet the literature is filled with episodes of people who are completely and utterly brain dead responding to stimuli. There's about 40% of dead people who, if you touch their feet, the foot will recoil. There are spontaneous acts by brain dead people. So I don't think that a response to by a fetus necessarily proves that there's a sensation of pain or that there's consciousness. Justice Sotomayor has received some very harsh criticism for this question, but I think it's an important one. If the Constitution says you cannot be deprived of life without due process, which happens to be my legal argument against abortion, figuring out when life begins would be an important step. Sotomayor claims that 40% of brain-dead people react to stimuli and have spontaneous acts. Does that statement hold up? Well, Merriam-Webster defines brain death as final cessation of activity in the central nervous system, especially as indicated by a flat electroencephalogram for a predetermined length of time. If there is no activity in the central nervous system, then there can be no spontaneous actions. Since a flat electroencephalogram may not rule out reflexive movements similar to touching of the foot, Justice Sotomayor seems to have a point. So I searched federal law for a definition of brain death, but could not find one. Now, this makes sense since the power to find medical conditions was never delegated to the United States. However, I did find it in the Mississippi Code annotated. An individual who has sustained either A, irreversible cessation of circulatory and respiratory function, or B, irreversible cessation of all functions of the entire brain, including the brain stem, is dead. A determination of death must be made in accordance with accepted medical standards. There has been medical evidence that children in the womb react to stimuli, but is that enough to prove life? Now, if their reactions are merely reflexive, such as flinching from pain, proof of life might be questionable. According to the Mayo Clinic, by 16 weeks gestation, the baby's eyes and limbs move on their own. This spontaneous movement shows activity in the baby's brain. Furthermore, according to the Charlotte Lozier Institute, a recent review of the evidence concludes that from the 15th week of gestation onward, the fetus is extremely sensitive to painful stimuli, and that this fact should be taken into account when performing invasive medical procedures on the fetus. It is necessary to apply adequate analgesia to prevent the suffering of the fetus. If, at 15 weeks gestation, it is necessary to protect the baby from suffering, then doesn't the baby also deserve the protection of their life? There have even been reports of the baby in the womb attempting to get away from the abortionist's tools. If the child in the womb has a consciousness to attempt to escape from danger, can we not agree that it's alive and deserving of our protection? There was so much more in these oral arguments that I do not have time to deal with them here. The question of undue burden, or is the opposition to abortion merely a religious view? The relative safety of abortion compared to giving birth, even the assertion of Justice Sotomayor that the Supreme Court has the final word on what is constitutional, are all worthy of further study. Whether I cover those topics in another episode or not, I will certainly review the court's decision when it's released. Regardless of where you stand on the topic, it is clear that the question of abortion will not be leaving the social discussion anytime soon. Most of my life, Roe v. Wade has been a controversy in society. Most of my life, people have demonstrated against it every January. And from the time I started studying the Constitution, I recognized the inherent flaw in both the Roe and Casey opinions. Now, many people claim that the court invented a right to abortion. Well, sort of. They simply say the right to abort is your liberty, living without external influence. And they have a point. But they also forget that the 14th Amendment's Due Process Clause protects life. And the part that was missed was, when does life begin? Now, in 1972 and 73, Our understanding of the gestational process was not as advanced as it is today. Yeah, we knew there was a baby, we knew it developed, but we had limited information about the activities in the womb. As technology has improved, we see more and more evidence of life, proof of life of the child in the womb. And since the Constitution, the Due Process Clause, says a state cannot deprive anyone of life without due process, doesn't that exist for the child in the womb? Sure. Justice Sotomayor and many others on the court focused on a woman's right to not be pregnant, a woman's life to terminate a pregnancy, completely ignoring the question of the child in the womb. I agree. A woman has a right to control over her body until that action impacts the life of someone else. I used this example once when someone asked me about abortion in the case of rape or incest. The lady I was talking to was married, and I asked her a simple question. I said, God forbid you should be raped. I would not wish that on anybody. It's a terrible, awful thing. It would be not only physically traumatic, it'd be mentally traumatic. But let me ask you, would you be allowed to kill your husband because every time he reached out to touch you, you recoiled in reaction to that rape? Now, the obvious answer is no. Well, if that's true for her husband, why should that be any different for her child? Sure, she didn't plan it, and I can understand the psychological issues, but does that mean she has the right to kill it? The other thing I think gets lost in a lot of these discussions and tends to be diverted by the questions of rape and incest is women don't just magically get pregnant. You don't catch a pregnancy like you catch the common cold. Pregnancy is a consequence of an action. And if my studies are correct, the vast majority of abortions are avoiding pregnancies that are consequences of voluntary actions. The woman did something and got pregnant. Well, since we have all the technology we need to help prevent pregnancy, why is abortion considered a viable option? Why kill something because it's a consequence of an action you either were unwilling to take or unwilling to restrain yourself from it? It's a difficult discussion to have, but let's face it. If you're claiming the right to terminate a life for something other than due process, something other than a threat to your life or your health, what you commit is murder. I feel for the women who have gone through this. I feel for the men that have participated in this. Some of them, I'm sure, have been seriously traumatized. But if we allow the court to place the political machinations above the supreme law of the land, then the right to life of the child is not the only one in danger. See, if the court can decide that a child's life can be terminated simply because it hasn't exited the womb yet, the very same court can demand that your life be terminated for someone else's convenience because the world is overpopulated or there's too many greenhouse gases. The court can also demand that you get vaccinated to protect you from a disease you might spread to somebody else. See, to me, as much as Roe v. Wade and Planned Parenthood v. Casey are about abortion, it's really about who runs this country. Is it we the people, or is it the oligarchs in black robes? Right now, the oligarchs are in control. The question is, will we fix that? Now, if you want more information, again, please head to constitutionstudy.com. You can share this video, share the article, share the podcast episode. All of it's there for you to share. All of my articles are there for you to research, for you to use, and for you to share absolutely free. Yes, there's a store. It links you to another website, but you can, and if you want to support the Constitution Study, there's a donation page there as well. Help keep these videos coming. Help keep the podcast and the articles going. I would appreciate that greatly. But more and more I'm being asked, what can people do to study, or in many cases, to teach their children? And While the Constitution Study is a great place and the books I have are very useful, please check out constitutionscholars.com. It is designed for people who want to be students of the Constitution, whether it's I'm just getting started or I want to do a deep dive. Now, it's absolutely free to sign up. You get access to community groups. Right now, they're based primarily on states, but I'm trying to get some people together to create other groups for other ideas and other topics. But you can go there. You have a library of resources. You have classes and webinars that I put on up there. You have others you can share information with. Place you can ask questions, get answers, have interactions. That's all there on constitutionscholars.com. Now there's more, but I'll let you go investigate that first. But I hope you find these videos useful. I hope you find the analysis helpful. At least helpful enough that you'll come back here next time for the Constitution Study.